Board. Okay, and welcome everybody who's on. This is Mary Zambry. I'm glad you were able to join us today for pursuing insurance for COVID-19 losses. And Gary Thompson will be joining us shortly. But on the screen now, we have our longtime valued sponsor, Jerome Page. He's a silver sponsor with our group. And he's going to tell you a little bit about his business and how he can help you.
Thank you, Mary. I'm only going to take about 2 minutes just to highlight a couple of things. And looking at the participant list, I see a lot of familiar names, Chris Nace, and Ron Karp. And so hello, everybody. Good to see you virtually. So again, my name is Jerome Page, and my firm is Jerome S. Page and Associates. We're an economic, business, and organizational consulting firm. I just wanted to take a moment or two to remind you that for your clients who are small business owners, independent contractors, or gig workers, I want to remind you that their economic damages are measured by the loss of net profit, not the loss of revenue. That's an important distinction to keep in mind. Because of the ways in which small businesses maintain their financial records, many of them, for legitimate reasons, don't make a profit or have a positive net income for tax purposes. Revenues may be high, but profits are low. In our jargon, we say they're living off the cash flow. If they're living off the cash flow, they may not be able to demonstrate any economic damages. So it's important to involve us or any economic expert early in the process for these types of cases. Recently, we had to inform an attorney who had retained us that the deceased didn't report a positive net income on their Schedule Cs for several years. So if the claim is the loss of profits or the loss of net income, then in this case, if this is a wrongful death case, so there was nothing left for others because the decedent didn't report any income. Now, there are some potentially novel ways to get around this, like accounting for what we call the loss of lifestyle expenses, or using a technical financial term, the determination of free cash flow. And these get to be a little technical and speculative. So that's why it's important for us to get involved earlier. The earlier, the better. In addition to estimating damages for independent contractors and gig workers and small businesses, we also determine economic damages in personal injury, wrongful death, wrongful dismissal, medical malpractice, and contract cases. In addition, we conduct the evaluation of life care plans. So you can contact us for a free discussion for your cases. Our offer runs until we reach phase 3 of the reopening. So call us if you have any questions about what are the potential damages. We won't actually be estimating the damages, but give you some sense of how you can think about valuing the case as you move forward. So give us a call, have an informative seminar, and we look forward to hearing from you. Thank you.
Thank you, Jerome, very, very much. Okay, and all of Jerome's information is available on our website, or this is Mary, you can just write to me and I'll give it to you. Okay, now we're gonna come over. I think I did this correctly. Hopefully we're seeing Gary up at the top and we're sharing Gary's screen, correct? Yes. Okay, so I'm going to turn it over to you, Gary.
All right, thank you, Mary. Hopefully everybody can hear me okay?
Yeah, I can hear you just fine.
Okay, great. and you can see my screen, hopefully.
Yep.
So I will jump right into our topic. Briefly introduce myself first. My name is Gary Thompson. I'm a brand new member to the DC Trial Lawyers Association. I thank my friend Greg Smith for inviting me. Very pleased to join. I have a small firm with just 3 lawyers, and we specialize in representing policyholders with insurance claims. We fight against the insurers. We try to collect on claims. It's something that I've been doing for about 30 years. And I've covered just about all lines of insurance. I'm especially pleased to be a part of the Trial Lawyers Association finally, because I spent most of my career in big law firms. Most of the policyholder side groups are found in firms like Covington and Reed Smith, Perkins Coie. A lot of big firms around town have, pretty sizable, formidable policyholder side groups. And I've always been in one of those, wedged into a big firm, but also being a plaintiff side lawyer, which is a rare animal for the big law firm world. We always had to deal with conflicts and issues like that. So my 2 partners and I, Julie Hammerman and Kristen Davis, were very excited to break away and start our own practice. We are plaintiff side pure, policyholder side pure, no conflicts, and we have been very busy since we started our little practice last January. And when COVID-19 came along, it's an odd coincidence with our specialty. My true subspecialty is property and business interruption insurance. So I've been pursuing that since before September 11th. After 9/11, I did one of the big World Trade Center claims, and after Katrina, I did dozens, maybe hundreds of hurricane claims, lots of floods and earthquakes and construction defects and pollution and all the sort of traditional things that trigger property coverage. But along the way, there are always these sort of unique, non-traditional claims that we've dealt with over these many years. Once upon a time, cyber breach, which now has its own entire coverage product. We dealt with SARS in its original, 1.0 version in 2002-3. Zika, odors. There are all kinds of things that trigger property coverage, other than sort of your traditional tornado, fire, flood that normally triggers it. So before I dive in any further, I invite questions. I've left a lot of time at the end for questions. I really want everybody to, just throw out your questions. If your client questions, your questions about how all of this works with COVID-19. And I also woke up this morning thinking, gosh, I should probably do a slide on coverage for civil commotion, which is suddenly at the forefront of my inbox. So maybe I'll talk about that a little bit at the end, but sort of taking a little bit of a step back first. I know probably most of you understand what property and business interruption insurance is. This slide is just kind of the basics. It's what is generally called all risk coverage. Property policies cover all risk of any kind of physical loss or damage, whatever that might be, unless it's excluded. Once upon a time, it was just fire insurance, and then it was fire plus certain specified perils. What we used to call the 7 plagues coverage, but then they just broadened it to everything. Everything unless it's excluded. So that your starting point in a property policy is yes. And that's a nice place to start. Typically, although not necessarily, commercial policies include business interruption coverage, and that's really what we're going to get to here. And as Jerome alluded to in his presentation, what you're primarily covered for are your lost net profits during the period of interruption. If you're a restaurant and you're out of business for a year because of a fire, you get your lost net profits if you were going to be earning them. The product also pays for your continuing fixed expenses like rent, taxes, insurance, the things that don't go away during the time your business is down. So its basic formula is lost net profit plus continuing expenses, plus extra expenses like generators or things that, expenses that are not a part of your normal course of operations that have come along because of the event itself. Like paying hazard pay or overtime pay to have, like in this context, to have extra staff maybe to deliver food or to curbside pickup, that kind of thing. Most policies also include a business interruption coverage extension called civil order, civil authority. And the general concept is if something has happened, like a physical loss event, sometimes a large fire or explosion or something, there's an area that's blocked off by order of civil authority. And if your business hasn't been damaged at all, but is still interrupted because of this civil order, you have coverage for that. And you'll see in a moment how that arguably is triggered by the COVID-19 orders of civil authority. There's dozens and dozens of pages of endorsements and cryptic words and phrases. Lawyers, any lawyer has got a great head start. Anyone that's dealt with insurance policies, has a pretty good understanding. When you live with these things every single day, breakfast, lunch, and dinner, there's lots of context and history that help inform how we interpret policies. The sort of big picture principles that I always try to invoke, and these are important, is ambiguity is always construed in favor of coverage. That's because these are contracts of adhesion. They're policy forms written by the industry. It's what the law calls contra preferentum. The tie goes to the runner. I mean, you're looking at dense words and phrases, probably in between a policy form and an endorsement, maybe another endorsement, maybe some words on a declaration page. If it's fuzzy, if it's hard to put together, always remember ambiguity is always construed in the policyholder's favor. The second point is that if it's an exclusion or a limitation of coverage, like a virus exclusion or something, those are always construed as narrowly as possible. And the emphasis is always on the policyholder's reasonable expectations, which is often a fact issue. It depends on who you are. Do you own a restaurant? Do you own a car dealership? When you bought insurance, what were you expecting? Yes, you have to read the terms of your policy, but the client, the customer, is not expected to be a technician. So there's great deference to the client's reasonable expectations. Paper is always a mess, and I can tell you, insurance policies are not in order. They're not supposed to be in order. It's just a jumble of paper. These days, when it's all PDFs, it's just like you open the thing up and you can't even tell, where does this thing start? It doesn't have like an index. It's just a mess of pages. Basically, there's the main page is called the deck page, the declarations page. It tells you the name and the limits and information about the deductible and whatnot. And there are the main policy forms, which are kind of sometimes all over the place. And if it's a package policy, there's property and general liability and maybe errors and omissions and maybe boiler and machinery and maybe something else, employment in the main forms. And then there's just a mess of endorsements seemingly in no order at all. And then a bunch of notices that are just kind of scattered all over the place. Take the paper, organize it in a logical way. Sometimes there's actually is an index of forms so you can check off to make sure everything's there, but there's no magic to the order. The main standard form is issued by the Insurance Services Office, or ISO, and I put a little image of an ISO mark at the bottom of policy paper, and it usually has a policy form number. And that's the main one. There's lots of other standard industry forms. Lots of companies have their own proprietary forms, like State Farm. They're industry driven. For larger commercial clients, quite often policies are manuscripted. They're basically tailored to that particular client. But even then, usually somebody just takes a standard form and tweaks it, adds some words, adds a specialized coverage. The big brokers all have kind of their own basic forms they use to create these manuscripted forms. Willis and Aon and Marsh. You can tell if you do this all the time, like just with one glance, like, oh, I know this form. This is an old FM Global form modified by Gallagher. So that can help inform context. It's partly why it helps to have a specialist, but typically at least in residential and small business policies, there's supposed to be notices about important exclusions. So there's the mold exclusion or the flood exclusion, or maybe the virus exclusion, but there's also a corresponding notice that says kind of in big bold letters, look out, there's a virus exclusion in here. It basically excludes loss from virus. It's supposed to be near the front. And then, somewhere in the middle of all this, not necessarily all on the declarations page, is a labyrinth of information about deductibles and limits, sublimits for certain types of coverage, coinsurance if there is, coinsurance and other information that impacts how much you're covered for. It can all be a little bit more complex than it should be. I mean, like so many things, the industry's broken. It's meant to rig the game in favor of the insurance industry. It's meant to be confusing. It's meant to be impossible to decipher. The insurers love it that way. For example, there's no need to have endorsements. In the digital age, where everything can be immediately digitally unified, there should only be one policy form, period. Endorsements are a relic of the past when they literally used to have to assemble paper, but insurers still do it because they know it's confusing. They know it. They know that in 90-something% of the cases, the policyholder is not represented, probably not a lawyer, doesn't have the background to decipher what the heck all this is. And, especially with small businesses, definitely with homeowners, the insurance companies try to call the shots. It's a thoroughly broken industry in that regard. And generally speaking, insurance commissioners are weak. There's a few good ones in the country, but by and large, they are captives of the insurance industry. They just repeat the talking points that the insurance industry would like to get out there. They stamp forms, approve forms, make sure reserves are checked and do the sort of financial accounting type stuff. They try to raise money through a captive program. They try to do some financial things, like in DC, they're part of DISB. But they rarely represent the consumer. Occasionally a politician tries to wake them up to that reality. Hey, what about consumers? It's a difficult dynamic. So policyholders who don't get their claims paid either only have themselves to fight like hell, don't take no for an answer, or if they can afford it, a lawyer. And I'll loop back into that when we talk about bad faith. But so COVID-19 comes along. It's like nothing we've ever seen in our lifetimes. The big question is COVID-19 a physical loss or damage event that triggers business interruption? Is there civil authority coverage? Can you get around a virus exclusion? What about a pollution exclusion? If they don't pay, is there bad faith? Can there be a class action? These are all the things I'm going to jump into. So I decided to sort of start at the back end. I mean, normally you look at coverage first. Is there coverage? And if the answer is yes, then you turn to, well, then are there any exclusions? That's the logical order, but I thought I would flip that and start with the big problem that many policyholders have, and this is it. In 2006, the Insurance Services Office introduce this virus exclusion. Here's what it says. They're not going to pay for any loss resulting from any virus, bacterium, or other microorganism that induces disease. That is a formidable exclusion. They, the way they pitched this to insurance commissioners in an accompanying memo is they said, "Oh, this is nothing. This is the pollution, the generic pollution exclusion already excludes this, and so we don't really need this. But oh well, I guess we'll just throw it in as belts and suspenders just to make sure it's clear." Kind of snuck it in with that sort of representation, but of course, once it got approved into forms, they thereafter wave it around for any claim that has anything to do with virus or bacterium. And even if the pollution exclusion doesn't apply, they say, oh, that's something completely different. So there's a little bit of a bait and switch that's happened with the history of this exclusion, but it's, and that's troubling, but as the years have ticked by, now 14 years, you see it in many policies. It's a standard part of the ISO product, and it's a problem. And I looked hard, and I've spoken with maybe 50 other policyholder side lawyers. We've had our own internal conferences and in intelligence sharing, and right now people are not optimistic about getting around this if you hit it head on. So, you know, if somebody doesn't have a lot of time to have me look into this or something, I say, you know, just look and tell me if you've got a virus exclusion. If you don't, let's talk. Maybe there's a chance we can get some coverage for you. You know, I'm not saying it's a full stopper, because there's a couple of other process issues that we've all been exploring. Was like these. Was the exclusion slipped into a policy during a renewal without notice? That's a big no-no. You know, we all renew our policies year after year after year, like your own auto policy. You don't ever read it. You don't ever get it. You don't have, I mean, maybe you get something in the mail sometimes that says, notice, there's a new total water exclusion now in your homeowner's policy, by the way. I mean, that notice that goes out, the ones that hardly anyone reads anyway, but that notice that goes out is an important part of the process. So, you know, is there a matching notice provision with the virus exclusion? If there's not, and this thing has kind of covertly found its way in, then there's sort of an estoppel argument, maybe even a regulatory estoppel argument, which I alluded to when I was talking about the whole history of the form. But that's got a little bit of promise, that kind of argument, which is, hey, you might not be able to take the virus exclusion head on and say, that's not what that means, because COVID-19 is obviously a virus. But if you come at it from the side with one of these process arguments, you might have an argument that it doesn't belong in the policy. The insurance company is stopped or precluded from asserting it. And then the final point in this regard is broker malpractice. You know, we all rely on brokers to sort of get the right product for us. So, you know, if you happen to be, say, a nursing home, and you know, you need a specialized product, and you go to a broker, and your broker says, yeah, here's this product from Geico or whatever, you know, just some cheap product, that could be malpractice. I mean, any broker knows that if the policyholder is a nursing home, there's a certain, or a healthcare facility, there's a certain kind of insurance product that should be purchased. And that standard product for healthcare facilities does typically have communicable disease coverage that overrides any kind of virus exclusion. It's what you would expect, of course, because healthcare facilities are places where bacteria and viruses and spread, and they could shut the place down instantly because of the nature of that operation. So, you know, I don't like to sue brokers, but that's always a question to ask. If the answer is no, there's no coverage, the follow-up question is, well, why isn't there? You know, should there have been? Whose job was it to figure this out? I mean, if you're just a restaurant and you went out and bought a standard ISO product and it has the exclusion, the virus exclusion, there's probably little you can do. But you know, everything depends on the circumstance, the policyholder, what the situation is. There's lots of other exclusions to worry about. Some of them, and there's the ISO one is just sort of one of the big standard ones, but I've seen dozens and dozens, and it's amazing how different they all are. Some don't use the word virus at all. Some refer to communicable disease. Some refer to contagious and/or infectious disease. I've kind of listed these in the order that they worry me. Communicable disease, contagious, infectious disease, that worries me. Might not say virus, but that's a higher hurdle. If it just says disease standing alone, which is usually there's a standard ISO product that has an exclusion for disease on the property side of the form, along with, like, for some reason, vermin and like mice and insects and disease. Like, what does that mean? I mean, I get into the context of that one, and it doesn't impress me. I'm not too worried about that one standing alone. There's an older one that just says SARS, and that clearly comes from the 2002, 2003 SARS outbreak. And I don't think that applies, although someone has pointed out, well, technically COVID is SARS-CoV-2. It's like version 2.0. So that doesn't worry me too much. The word microbes, the word microorganisms, science has had this debate for a long time. What is a virus? There's arguments to be made on both sides of those words. It's definitely not a bacteria. That's for sure. We know that. The word microorganism connotes to me that it's a living thing, and a virus is not a living thing. Microbes is a little more worrisome because it basically can, in some definitions, include virus. But the context of the words, where I see these words, usually doesn't worry me. Then there's just the pollution exclusion, and there's lots of different kinds of pollution exclusions. Sometimes the word virus is in the pollution exclusion, and that can be a problem. But a lot of times I see it with a modifier. It says like bacteria, virus, chemicals, irritants, as listed in Federal Clean Water Act or Clean Air Act, et cetera. So it's clearly referring to like traditional pollutants, and not sort of an infectious disease virus. And there's some good kind of contextual drafting history to help get away from that word virus in that context. And then there's just pollution exclusions that don't refer to virus at all. It just says all contaminants. Well, what's a contaminant? That's, the insurance industry wants it to be everything. Air is a contaminant, they will say. So is water. But, remember, exclusions are construed narrowly, and I'm not too worried about a generic pollution exclusion. In fact, I typically, if it's just a pollution exclusion and there's no ISO virus exclusion, I say, well, there's no virus exclusion. So they had that available to them, and the insurer chose not to use it. They chose not to make it endorsement, 28 or whatever, slap it onto the form. So surely the pollution exclusion standing alone doesn't exclude loss from virus. Quick point on the flip side of this is some clients have pollution policies, like a whole separate pollution program. A lot of hotels have that. Some restaurant chains do. And typically that's for, we found an underground storage tank, or there's an old PCB, capacitor, or something like that. Sometimes when there's a fire, there's asbestos comes out of the walls or whatever. Sometimes when people have affirmative coverage for pollution, then the shoe's on the other foot, and you construe exclusions narrowly, but you construe coverage broadly. So it's totally consistent if you're on the affirmative pollution coverage side. If you're looking at standard pollution trigger language, like the word contaminants, to say, well, that definitely includes COVID. It's not included if it's an exclusion, but it's definitely part of the coverage if it's a coverage grant. So there's sort of a flip side to that. And if you're lucky enough to have a client with both, you can kind of play it off each other. You can kind of bait the main carrier to deny coverage based on the exact pollution exclusion wording that also grants coverage in your other program. before I talk about sort of the big issue, which is whether COVID is physical loss or damage, you know, let's say you don't have the virus exclusion at all, and now you're, or any other exclusion that you're worried about. Now you're on the covered side, you know, and your number one argument is going to be, this is an all risk policy. I'm covered for everything unless there's an exclusion, and there's no exclusion. There's no virus exclusion in this policy. It's an all risk policy, period. End of story. That's a good argument. You know, the insurers will say, well, hold on, physical loss or damage is the trigger of coverage, and that still means something. COVID has to mean that. But you really got a good head jump on them, you know, out of the starting block, if you don't have an applicable exclusion. But before you sort of, like, the main trigger of coverage, if COVID is physical loss, gets you to the full policy limit for property, the full policy limit for business interruption. But before you go there, lots of policies have specific coverages, and you can mine a lot of limit or sublimit with a close examination. And these things are hidden everywhere in property policies. Some policies have coverage for communicable disease. A lot of my hotel clients have that because Legionnaires is sort of one of the biggest problems in hotels, Legionnaire's disease. And when you're hosting banquets and having, you know, conferences and all that kind of stuff, people can just get sick from something that is going around, norovirus, everybody's worst nightmare. You know, that's why it's there. And the language clearly encompasses COVID-19. So, you know, that's kind of the easy, that's kind of a layup. There's one called biological agent, which by itself doesn't sort of connote coronavirus, but when you read the definition, it says and virus. Biocontamination sometimes, it typically has the word virus. Disease contamination, definitely. An odd one is fungi, bacteria, and virus. Take the word virus out, you just have mold coverage. And I look at the mold coverage, and you have to go to the definition of mold, and you read the definition of mold. And it obviously, a virus is not mold, but you know, COVID is not mold as we think of mold, like the green and black stuff on the wall. But the definition captures it because it sometimes has like mold, microbes, microorganisms, or other, you know, agents that. So it's you know, there's lots of these words where you can start to drive a wedge in for COVID-19. Like the word microbes is a good one. There's lots of weird gateways in the coverage. I looked at a client's program the other day, and I don't know what prompted me to look at their cyber coverage, but cyber breach is kind of this new product that a lot of larger clients get. And so you look at their cyber policy. There's all these weird coverages. It's like from coverage A to like M. And near the end, there's just this miscellaneous stuff. And one of them was disinfection expense coverage. Why is that in a cyber policy? I don't know. It says we pay the cost, we pay all disinfection expenses, if you have any, from a covered disinfection event. And those words are defined, and it clearly includes COVID-19. So I said, great, there's $100,000. It was sublimited, but there's $100,000. The cyber insurer is still scratching their head like, oh, yeah, wow. So anyway, I mean, there's really no substitute for reading the whole darn policy. And are there other policies, not just the sort of main property program, but cyber or pollution, or, I mean, I typically just say, give me all your policies, all of them. I mean, I don't need to see workers' comp, but even CGL policies can have first-party property coverages embedded into them. So the number one kind of fact that sort of gets a COVID claim going is there COVID on site, or have members of the staff come down with COVID. You know, then you've got a physical presence of COVID on the site. By the way, some coverages say the actual not suspected presence the disease or the virus. But some actually say the opposite. They say the threatened or suspected presence. Well, then you don't even have to have it. I mean, if you're like say an operating room and someone suspects there's contagious agent in the room, it doesn't matter whether there is or isn't. You're going to clear it out and decontaminate it. So sometimes that's enough. But generally, right now, all the carriers are saying, well, do you have COVID on site? Did you document it? Did you report it? This sort of reporting, this course of show me, has prompted me to kind of advise my clients to document the heck out of everything. And then I just wanted to show you this other coverage that is kind of the number one argument being litigated right now is the civil authority coverage. You're generally covered if an order of civil authority prohibits access to your property due to direct physical loss or damage other than at your location. So it doesn't have to be you. It can be someone else in the vicinity. This is the standard ISO language at the bottom I've highlighted where it says more than 5 miles. So the concept is in your vicinity, in a 5-mile radius, is there physical loss or damage that has caused this order of civil authority to issue that has interrupted your business? And there's some steps along the way there, but you can already see how these COVID-19 civil orders are arguably triggering this coverage. I mean, these orders weren't issued just for the heck of it. They were issued because COVID is present. It's ubiquitous. And so that's what's leading the charge right now. I always look for the word prohibits first and see if it can be a little broader. Prohibits has been construed pretty tightly, like you have to literally be prohibited, like it's illegal to go to your property. This one says, this is an example of one that says limits, restricts, or prohibits. So, oh good, I like limits, that can mean anything. But whether you're dealing with straight up business interruption coverage or civil authority coverage, you'll notice like in this language below where I've highlighted restricts or prohibits, it's direct result of physical damage of the type insured. Most policies say physical loss or damage. So that's the doorway in to kind of the big limits. And in most cases, civil authority limits or sublimits. Is COVID-19 an event that constitutes, quote, physical loss or damage? So that's the phrase, physical loss or damage. It's in almost every policy I've ever seen. And we always make this point, and I've never heard a good response, which is physical loss must mean something different than physical damage. I mean, if they just collapse into the same thing, why are there two different words? And insurers like to say, oh yeah, physical damage. You got to show physical damage. And they just kind of fly right by physical loss. Like, it means the same thing. It doesn't mean the same thing. You can physically lose something and it doesn't necessarily need to be like structurally damaged. And by that, I mean loss of use. So if you sort of back up to the word physical for a moment, I mean, COVID-19 is clearly a physical thing. It's not a ghost. It's not floating, an invisible thing that just floats around. I mean, it's literally a physical thing, maybe very small, but it's real, and it's incredibly dangerous, and it's a physical danger. So it's a true physical danger that you face when you walk into an indoor space with other people, at least, except for the people in your own house that you've been isolating with for a while. It's dangerous, physically dangerous. And because of that, these orders of civil authority have issued saying those businesses are closed. You cannot go there. You cannot assemble there. Yeah, if you're a restaurant, you can do some curbside pickup, or maybe you can have some tables out on the sidewalk, but you can't go inside. That is a order of civil authority that interrupts that business because of a physical issue, and there is a loss of use because of it. And insurers just like to sort of throw out these one-liners like, well, that's not what the coverage is for. I mean, read the words. We actually have the upper hand when we dive into the details, and there's really good case law that we're going to debate about in all these cases to be litigated. But the more you look at the cases, you find dozens of examples of cases that don't involve physical damage to the structure itself, like bacterial contamination of water. Can't go in there. Odors. A lot of meth labs that leave a horrible odor behind in a house that renders the house useless. You can't go in there. It's too overpowering. There's even one involving cat urine. I mean, the odor cases are great for this precedent because in all of those cases, all that's left behind is this physical odor that does everything else. Everything's fine. The walls are intact. The roof is on there. It's just, there's just been a physical loss of use. So we like our argument. We're anxious to get it teed up. And if the answer is yes, and courts are going to go both ways on this. They just are. You can see it two different ways. But if the answer is yes, then the gate is open. Ambiguity is construed in favor of coverage. So, we've got that point too. If it's a jump ball, like when I'm in court arguing and I say, well, Mr. Jones makes a reasonable argument. Your Honor, we make a reasonable argument. How are you supposed to choose between two reasonable arguments? The answer is, well, you've got a tiebreaker. Nobody has to lose here. You resolve the tie in favor of coverage because there's two reasonable ways to look at this. You don't even have to be right. You just have to be reasonable. If you get into the doorway of business interruption coverage, this is where somebody like Jerome can help you. Generally, you take your pre-loss projections, your budget, your pro forma, usually a budget. Compared to your actuals, you claim the difference. Is there anything else that explains the difference? Something else that kind of came along, like some unexpected debt or liability? Nope. That's your shortfall is your coverage. As I mentioned before, it's lost net profits plus continuing expenses plus extra expenses. We're going to have this little academic debate with business interruption insurers about do you take into account the impact of the event itself. So this is insurers at their most cynical. They say, oh yeah, okay, it's fine. So if your restaurant experienced a COVID-19 event, and if that constitutes physical loss or damage, well, you weren't going to get any business anyway because everyone's at home isolating. So it turns out you didn't have any business interruption directly caused from COVID. Directly. Indirectly, yeah, because it's the reason for the entire downturn in the economy. We don't count that. That's indirect. That's remote. And they have some exclusionary language I'd like to point to. That's a completely bogus argument. We've defeated it over and over, and there's good case law on it. Litigation to date, I've lost count. I used to try to read them all. There's somewhere approaching 300 cases filed across the country now. DC, Maryland, and Virginia, there's plenty. There's a couple in the Rocket docket. By and large, restaurants are leading the way. They were the first ones out of the box. There's some very prominent restaurant groups that have filed cases based on more than one of their restaurants. There's a lot of one-off restaurants, bars. They all make good arguments. I've seen some excellent complaints, some much, much better than others. They're on their way. Those of us who specialize in this, we filed some of these, but most of these are filed by lawyers that don't normally specialize in insurance recovery. And, that's okay. The great they're making the charge, but we tried, at least for the early ones where we're worried about precedent, we're trying to get in there and help. So I filed an amicus brief yesterday in a case in Florida called Prime Time. It's one of the first ones teed up for summary judgment. We're super skittish about these first dozen summary judgment rulings because, we saw this happen after 9/11 and after Katrina. The first couple of rulings starts the momentum, and judges like to rule the same way another judge ruled. It's sort of a dangerous time in the legal landscape. And we found that the lawyers that are out there with these cases that don't have the experience are happy to have amicus support or even, accept a little ghostwriting. It's hard on the policyholder side. We're not as organized as the insurance industry. The insurance industry is powerful. They have entire law firms like Wiley Ryan that do nothing other than track cases and coordinate. There's only like 10 major insurers to start with. And they all have these powerful firms like Skadden Arps and others that, are all over this. They're, associations, lobbyists, they're just coordinated, and that's difficult. The policyholder side, they basically have us, trial lawyers associations. There's a informally organized group of policyholder side lawyers. There's this one nonprofit called the United Policyholders, and they're really kind of the best consumer-oriented, pro policyholder organization out there. They got some great materials on their website. And then meanwhile, you probably have noticed a lot of firms have gotten the idea of, well, let's try to certify a class action, or let's take this to MDL. There's almost no precedent whatsoever for a class action in a context like this. It's a huge uphill climb. My view on this is it depends on the proposed class. The idea of this is a class of all policyholders. At one extreme, this is a class of all policyholders with insurance coverage of any kind against any kind of insurer. That's not going to fly. Every single contract is different. These are breach of contract cases. So class treatment for breach of contract is generally tough if you're not at least all under the same contract. So an example of one that I saw that I think is suitable for class action treatment is a group of franchisees, all the same franchise, it's business in a box. And this is when you sign your franchise agreement, this is what you get. Everybody gets, these 19 things. Oh, and here's your insurance policy. It's all part of what we sell as a franchisor. Check that box, it's yours. Now you've got a case where you've got 1,000 class members. They all have the same policy, all issued through the same broker, all for the exact same business. We're all Taco Bells. We all sell the same thing. That stands a good chance. So those are going to be kind of all over the map. There's a lot of big plaintiff firms trying to organize these in different ways. I noticed Boyce Schiller's involved. There's some impressive filings. Some of these are going to go somewhere. And at the federal and level in some states that have it, some MDL treatment is probably going to be appropriate. What we're especially excited about on the MDL aspect of it is just discovery. How do you take on an entire industry? Because you got to get these drafting documents, and if you're just a little restaurant, one-off case, that's tough. Kinds of clients. This is the answer for all this is it depends completely on the policy, the language, the context, the level of contamination, if any, what kind of client you got. Restaurants we've talked about, I think they make great cases. They're shut down, and most policies say in full or in part. So in part, maybe not entirely, like every restaurant we know in DC, they're doing their best with some curbside stuff and using DoorDash or whatever, but their dining room's closed. That's an interruption. That is a physical interruption. Now, especially if they've had COVID on site, that they've had to disinfect, that gives a little extra legs to the trigger argument, but the civil authority argument is still there. And so sort of in a similar vein, retails that require close contact, gyms, hair salons, tattoo parlors, I mean, those are unavoidable. Those are places where close human contact's unavoidable. I think they make great claims. So do hotels, and places crawling with people. Healthcare facilities, nursing homes, hospitals. These are various places that are extremely sensitive to the idea of COVID infection. They've got specialized coverages. So do hotels. Sometimes restaurants do. University schools, dorms, I'm looking at some of those. I mean, how do you put a bunch of kids together in a dorm? The type of business usually dictates the type of policy they have. The policy that obviously has the least amount of promise is some kind of remote, mostly stay-at-home business that is indirectly affected. Like, I'm a middleman selling advertising space and for magazines, and I do it mostly at home from my laptop. But my level of business has gone down because of this broader sort of downturn of business from COVID right now. None of my clients are calling me right now. So you're kind of removed from it. I would, not, it depends, of course, but, and so I review that because that is the case some knucklehead brought in the Southern District of New York with a preliminary injunction motion, arguing a likelihood of success on the merits for COVID-19 coverage for that business. I forget the judge's name, but it didn't work. So now the very, very, very first opinion on this is not good because of some knucklehead. So hopefully the next case will go better. A restaurant, nursing home, healthcare facility, we'll see. There may have been a ruling recently that I haven't even heard of. I mean, it's hard to keep track now. I read Law 360 and everything I can, try to track it, but stuff goes around pretty quickly in our little listserv for policyholder geeks. Anyway, I wanted to do a slide on legislation. You probably heard about that. 9 states plus DC have proposed legislation. Mostly what these bills say is a declaration that an insurer must approve coverage for COVID-19, regardless of policy exclusions or policy language. I mean, I'm a policyholder advocate, but even that kind of stopped me in my tracks because constitutionally, I'm not sure you can retroactively override a private contract. But some of these bills are designed in a way that kind of gets around that. And I saw several, and I worked on the one for DC that I thought did, by adding a process for the insurer to, that has to step up and pay, have a due process for them to claw it back if there's in fact no coverage. You can divide that between, do they have the virus exclusion, in which case they don't pay at all. If there's no virus exclusion, they pay, subject to this right of reimbursement from a fund. It gets funded by a special fee to be assessed by the insurance commissioner during the next round of renewals. I think it works. I think it passes constitutional muster. It is not passed anywhere. Here in DC, a shout out to Councilmember Charles Allen. He was amazing leading this charge, and his attitude, which is my attitude, was we've got to try something. These small businesses are hurting. They need something, and they need it now. Almost every other council member took a big step back, and boos to the DC Chamber of Commerce because they fed the industry line to a lot of the council members. The DC Insurance Commissioner repeated the industry line. And they kind of wanted these talking points of, well, if we did that, then you would bankrupt the insurance industry. No, you wouldn't. I always remind people that every single year the insurance industry collects $1 trillion in premiums. $1 trillion. And they are paying out almost nothing right now on COVID. And at the same time, they're using the COVID crisis at renewal to jack up rates by about 130% in almost every case I've seen. They are profiting off of COVID right now. So they can make $1.3 million next year. It's bad. And this sort of fear that, oh no, we can't make the insurers pay a lot of money because we need insurance. I mean, yeah, we need insurance, but we don't need it to just sit there and do nothing and pay money for it to do nothing. Sometimes we need it to work. This is a moment of crisis. So a little bit of a soapbox there, but the final thing, there's this thing out there called PRIA, which is like TRIA, the Terrorism Risk Insurance Act. It's supposed to maybe patch up how this can work going forward, where at least going forward, insurers can start to offer coverage for disease, contamination, virus, contagious illness. But there's going to be this sort of reinsurance backstop that the federal government creates in case the insurers have to pay too much. We don't want them to pay more than $250 million. That's like the trigger point where then they can run to the fund and have the government basically subsidize the risk. And it's a good, I mean, it's worked really well with TRIA since 9/11, this whole concept of public-private kind of insurance arrangement. Anyway, that's legislation. Bad faith. If you get there with a claim and you've got a great claim and the insurance company just won't pay it, 48 states have really good bad faith law. Unfortunately, DC is at the bottom of the list. It's highly jurisdiction specific. There's some states have common law bad faith, like California. It's just a judicially created common law cause of action. We don't have that in DC. We don't have it in Virginia. There's statutory bad faith, like they have in Florida, in a lot of other states. It involves some fee shifting and or maybe a multiplier of damage. Maryland has an excellent bad faith statute. It's worked really well for my clients, especially those whose losses are under $1 million. In DC, we don't have that. There's no direct cause of action under the DC Unfair Claims Handling Statute. Most states have a private cause of action under that. Very standard statute. DC doesn't. There's a little, there's a good kind of backdoor approach in DC that I think works. We've seen it work in a recent case involving the Consumer Protection Act, which is sort of generally there to protect consumers from fraud. So if you're being defrauded by an insurer, if that's what it is, you don't have to use the phrase bad faith. It's just a phrase. It's still the same facts. You can fit it within the Consumer Protection Act. And in a lot of states, that's the preferred approach, like in Texas. And so Maryland and Virginia are very different from DC as well. Maryland has a statutory process. Virginia doesn't have much. It does have a statute that allows the judge to shift fees at the end of the case, which you almost never get to. So that's bad faith. What to do? I always tell people at least put in a claim. The most common question is, but will my rates go up? No, they won't and they shouldn't. There's nothing wrong with putting in a claim notice. If the insurance don't pay anything, they're not going to punish you by increasing your rates. At least they're not supposed to, and that could be an independent cause of action for bad faith. But especially if you think you've got a valid claim, of course, notify it. You can do it directly. A lot of times it goes through the broker on these accord forms, and measure your loss with help from somebody like Jerome. The carrier will start throwing requests for information at you. Answer them. I mean, they're like document requests, but usually they're not too onerous, or you'll get a denial letter. Get a denial letter, you're done on that, at least trying. If they're dragging it out, it's kind of an effective denial. And then at some point you decide whether you want to file a lawsuit. You want to do it right away? You want to wait? The answer is different for every client. Depends on the risk tolerance for litigation, the billing arrangement with you. Are you on a contingency? You have straight up billables. Like what? That's a whole other issue. So that's everything that I wanted to cover on COVID. I'll just finish with this little slide on civil commotion that I wrote this morning. I had to remind myself, oh yeah, that was a lot of property got destroyed last night, sadly. But knock on wood for the purpose of positive change. Basically, any property damage is covered from the phrase that found in policies is riot or civil commotion. So, you know, it's obviously if a store's window front is broken and things are taken or there's a fire, it's absolutely covered. So is business interruption. If you're not damaged, but your business is interrupted because of the protest, there's coverage for that too under civil authority. There's an old line of cases from the '68 riots that go both ways on whether the order of civil authority is triggers this kind of coverage. There's a not very good case in DC, but I think it's distinguishable. The bottom line is there's very good coverage for a business that's been damaged recently, whether it's a fire or some damage from civil commotion. So just thought I'd touch on that as a super topical thing, and that's all I got. And I love questions, so I don't know if there's any out there that Mary or anybody wants to shout out, but I'm happy.
Yeah. Gary, that was excellent. So informative. I'm so glad I recorded this because I know the members are going to really, really enjoy listening to this when they get a chance to do so. So I so appreciate you sharing your expertise with us. There is a question. The question is this: do you use expert witnesses in the prosecution of cases for plaintiffs? If so, which experts? And do you expect most of these cases will be decided by cross motions for summary judgment? Thank you. That's the 3 questions.
That's a great question. Yes, we use experts. I mean, the bigger the case, the more experts. On the physical damage side, you know, sometimes we need a causation expert. You know, someone to opine on the scope of damage, especially if it's something kind of fuzzy like mold or hurricanes. There's often a lot of questions about the scope of damage, whether building codes are triggered and that sort of thing, to define the scope of the rebuild. So there's that kind of expert. Probably the most common expert we use would be somebody like Jerome, to help define the business and income loss. We really need a forensic accountant to basically help you measure the loss, put it in the words of the policy, you know, take the stand and basically say, yep, this, you know, I looked at the last 5 years of budgets and P&Ls, and I projected this, and, you know, I counted for this, that, and the other, and the number is X. Absolutely. Sometimes we use a bad faith expert if there's standard industry, you know, custom and practice that has been breached by the way an adjuster has handled a claim. Absolutely. Especially if you're going for big bad faith damages. And miscellaneous experts for other things, but definitely yes. You know, as far as summary judgment goes, I do expect cross motions for summary judgment. Although I will say this: when you're the policyholder, generally speaking, you know, we try to get to the jury. I mean, any kind of a mixed question or fact in law, anything that we can argue to keep the judge from deciding the case on summary judgment. That's our instinct. Even if we could separate out a clean issue of law and we think we can win it, you know, I can argue the case law, I can pull out history and whatnot and win. I'd still rather try to avoid that contest, because if you can just get to a jury, and that can all be sort of couched into jury instructions, you know, where the judge instructs the jury on the law of insurance coverage, and there's 3 parts to a business interruption policy. Juries, they listen to that, but they're listening to you too. And when you get in front of a jury, you know, you always have to have a good case, but if your opening line is, ladies and gentlemen, this is a case about an insurance company that refuses to pay a valid insurance claim, 90% of your jurors are going to go, that's terrible. How much money do you want? I mean, you know, you've got to get in front of a jury every time if it's you against an insurance company. So that's where we want to be. if we're forced into summary judgment because a really good law firm, a really good lawyer has managed to kind of isolate an issue and tee it up, and you're in federal court and whatever, and you just can't avoid it, sure. And that's probably going to happen with a bunch of these COVID issues in some venue or another. And, we'll hope for the best, or if somebody loses, we hope that there's a distinction. I always like to say, if somebody loses, oh, well, they have that policy wording. Well, I have this other policy wording. That's different. So by distinction, it's really a good ruling for me. I mean, there's always a silver lining. But yeah, lots of legal, definitely a lot of cross motions for summary judgment on the way.
Okay, thank you for that. I see that Ron Karp has his hand up, so I'm going to give this a try and see if he still has a question. I'm going to allow him to talk for a moment. Let's see. Go ahead, Ron.
Can you hear me?
Yes.
Hi, Ron.
Oh, great. Thanks for this wonderful seminar. It really was excellent. I was especially intrigued by your comment about broker malpractice. I've looked at several policies for medical practices, which were just, shut down cold. And I'm wondering if you could make the argument that if you're an insurance broker and you are getting policies for medical practices, you should be especially careful around renewal time if they slip in a virus exclusion, because these people are seeing patients all day long at very close contact. And could you make the argument that the standard of care for a broker should be that when you represent whether it's a medical practice or a nursing home or any place like that, you shouldn't sell them a policy that has a virus exclusion?
Absolutely. That's a great fact pattern for that very argument. There's a lot of people say that when it comes to broker malpractice, especially brokers will say this, the only thing you can actually ever hold them accountable for is that they flat out failed to follow an instruction. Like, you sent them or something in writing that said, make sure I don't have a virus exclusion. It's in writing because that's going to hurt my business if there is one. And then they let one slip through. Okay, there's a paper trail, they screwed up. That's clearly broker malpractice. The sort of next best case is the kind that you mentioned where, brokers, especially the higher up the specialty ladder you go, have a standard of duty to sell the right kind of insurance to a policyholder, whether it's a lawyer or a doctor. Absolutely. If in that very case, you'd be pretty shocked if a broker let a communicable disease exclusion slip through to a dental practice.
Would you, for example, in a case like that, have an expert witness on standard of care saying that brokers should be exquisitely sensitive when they're representing medical practices to not allow these exclusions?
Yes, that is an excellent point. Probably a retired broker, somebody from the field.
Because most of the doctors that I've talked with are just very busy. They don't know what's in their policies. They don't know what happened at renewal. They just trust the broker.
That's right. And this is just a generalization, but I'll just call them old school brokers. Your old school brokers used to deliver that kind of personalized service to their clients, and they cared about that. And the industry generally today has become more and more standardized. Just go online and click and get your policy. It's less personal. It's less tailored. It might be shinier and easier to get and take a PDF and scroll it away in a folder, but it's not tailored. And that's what some of those experts are kind of like those old school brokers that say, wait a minute, I never would have let that happen using paper in my little office in Great Neck, so that you've definitely got some experts out there that would back you up on that kind of
Well, thanks again for your wonderful seminar.
Thank you.
Okay, I don't see that anybody else has their hand up or has a question. So Gary, we have taken more than an hour of your time, which was way more than we originally said. So I'm sorry that we took a little bit of extra time, but it was really so very interesting. And I thank you on behalf of the association for doing this for us. And we're so glad you're part of our association now.
Yeah, thank you. I'm so happy to be a part of it. I guess my contact information is out there somewhere.
Yeah.
ThompsonHD.com is our website, so you can just go to that and, you know, look me up, call me up, email me. I'll flag and, you know, field a question, you know, all courtesy, you know, stuff. If anybody in the association needs a little help or needs a case site or form, a brief form or anything like that. And I'll watch the listserv for any questions as well.
Thank you, Gary. Yeah, when I put out this recording, I'll also include all your contact information.
Okay.
Okay, well, be well, be safe, and thank you everybody for attending. Take care. Bye-bye.
Okay.